Spano v. New York, Supreme Court, 1959. Chief Justice Warren delivered the opinion of the court. This is another in the long line of cases presenting the question whether a confession was properly admitted into evidence under the 14th Amendment. As in all such cases, we are forced to resolve a conflict between two fundamental interests of society: its interest in prompt and efficient law enforcement, and its interest in preventing the rights of its individual members from being abridged by unconstitutional methods of law enforcement. Because of the delicate nature of the constitutional determination which we must make, we cannot escape the responsibility of making our own examination of the record. The state's evidence reveals the following. Petitioner Vincent Joseph Spano is a derivative citizen of this country, having been born in Messina, Italy. He was 25 years old at the time of the shooting in question and had graduated from junior high school. He had a record of regular employment. The shooting took place on January 22, 1957. On that day, petitioner was drinking in a bar. The decedent, a former professional boxer weighing almost 200 pounds who had fought in Madison Square Garden, took some of petitioner's money from the bar. Petitioner followed him out of the bar to recover it. A fight ensued, with the decedent knocking petitioner down and then kicking him in the head 3 or 4 times. Shock from the force of these blows caused petitioner to vomit. After the bartender applied some ice to his head, petitioner left the bar, walked to his apartment, secured a gun, and walked 8 or 9 blocks to a candy store where the decedent was frequently to be found. He entered the store, in which decedent, 3 friends of decedent, and at least 2 of whom were ex-convicts, and a boy who was supervising the store were present. He fired 5 shots, 2 of which entered the decedent's body, causing his death. The boy was the only eyewitness. The 3 friends of decedent did not see the person who fired the shot. Petitioner then disappeared for the next week or so. On February 1st, 1957, the Bronx County Grand Jury returned an indictment for first-degree murder against petitioner. Accordingly, a bench warrant was issued for his arrest. On February 3rd, 1957, petitioner called one Gaspar Bruno, a close friend of 8 or 10 years standing, who had attended school with him. Bruno was a fledgling police officer, having at the time not yet finished attending police academy. According to Bruno's testimony, petitioner told him that he took a terrific beating and that the deceased hurt him real bad, and he dropped him a couple of times and he was dazed. He didn't know what he was doing and that he went and shot at him. Petitioner told Bruno that he intended to get a lawyer and give himself up. Bruno relayed this information to his superiors. The following day, February 4th, at 7:10 p.m., petitioner, accompanied by counsel, surrendered himself to the authorities in front of the Bronx County building, where both the office of the Assistant District Attorney, who ultimately prosecuted his case, and the courtroom in which he was ultimately tried were located. His attorney had cautioned him to answer questions and left him in the custody of the officers. He was promptly taken into the office of the Assistant District Attorney, and at 7:15 p.m., the questioning began, being conducted by Assistant District Attorney Goldsmith, Lieutenant Gannon, Detectives Farrell, Lehrer, and Mata, and Sergeant Clark. The record reveals that the questioning was both persistent and continuous. Petitioner, in accordance with his attorney's instructions, steadfastly refused to answer. Detective Mata testified, "He refused to talk to me. He just looked up to the ceiling and refused to talk to me." At 12:15 a.m. on the morning of February 5th, after 5 hours of questioning in which it became evident that petitioner was following his attorney's instructions, on the Assistant District Attorney's orders, petitioner was transferred to the 46th Squad, Ryer Avenue Police Station. The Assistant District Attorney also went to the police station and to some extent continued to participate in the interrogation. Petitioner arrived at 12:30 and questioning was resumed at 12:40. But petitioner persisted in his refusal to answer and again requested permission to see his attorney. This time from Detective Lehrer. His request was again denied. It was then that those in charge of the investigation decided that petitioner's close friend Bruno could be of use. He had been called out on the case around 10 or 11 p.m., although he was not connected with the 46th Squad or precinct in any way. Although, in fact, his job was in no way threatened, Bruno was told to tell petitioner that petitioner's telephone call had gotten him in a lot of trouble and that he should seek to extract sympathy from petitioner for Bruno's pregnant wife and 3 children. Bruno developed this theme with the petitioner without success, and petitioner, also without success, again sought to see his attorney, a request which Bruno relayed unavailingly to his superiors. After the first session with petitioner, Bruno was again directed by Lieutenant Gannon to play on petitioner's sympathies, but again no confession was forthcoming. But the lieutenant a third time ordered Bruno falsely to importune his friend to confess, but again petitioner clung to his attorney's advice. Inevitably, in the 4th such session directed by the lieutenant, lasting a full hour, petitioner succumbed to his friend's prevarications and agreed to make a statement. Accordingly, at 3:25 a.m., the assistant district attorney, a stenographer, and several other law enforcement officials entered the room where petitioner was being questioned and took his statement in question and answer form with the assistant district attorney asking the questions. The statement was completed at 4:05 a.m. But this was not the end. At 4:30 a.m., 3 detectives took petitioner to police headquarters in Manhattan. On the way, they attempted to find the bridge from which petitioner said he had thrown the murder weapon. They crossed the Triborough Bridge into Manhattan, arriving at police headquarters at 5 a.m., and left Manhattan for the Bronx at 5:40 a.m. via the Willis Avenue Bridge. When petitioner recognized neither bridge as the one from which he had thrown the weapon, they re-entered Manhattan via the 3rd Avenue Bridge, which petitioner stated was the right one, and then returned to the Bronx well after 6 a.m. During that trip, the officers also elicited a statement from petitioner that the deceased was always on his back, always pushing him, and that he was not sorry he had shot the deceased. All 3 detectives testified to that statement at trial. Court opened at 10 a.m. that morning, and petitioner was arraigned at 10:15. At the trial, the confession was introduced in evidence over appropriate objections. The jury was instructed that it could rely on it only if it found to be voluntary. The jury returned a guilty verdict, and petitioner was sentenced to death. We find the use of the confession attained here inconsistent with the 14th Amendment under traditional principles. The abhorrence of society to the use of involuntary confessions does not turn alone on their inherent untrustworthiness. It also turns on the deep-rooted feeling that the police must obey the law while enforcing the law. That in the end, life and liberty can be as much endangered from illegal methods used to convict those thought to be criminals as from the actual criminals themselves. Accordingly, the actions of police in obtaining confessions have come under scrutiny in a long series of cases. Those cases suggest that in recent years, law enforcement officials have become increasingly aware of the burden which they share, along with our courts, in protecting fundamental rights of our citizenry, including that portion of our citizenry suspected of crime. The facts of no case recently in this court have quite approached the brutal beatings in Brown v. State of Mississippi in 1936, or the 36 consecutive hours of questioning present in Ashcraft v. State of Tennessee in 1944. But as law enforcement officers become more responsible and the methods used to extract confessions more sophisticated, our duty to enforce federal constitutional protections does not cease. It only becomes more difficult because of the more delicate judgments to be made. Our judgment here is that, on all the facts, this conviction cannot stand. Petitioner was a foreign-born young man of 25 with no past history of law violation or of subjection to official interrogation, at least insofar as the record shows. He had progressed only 1/2 year into high school, and the record indicates that he had a history of emotional instability. He did not make a narrative statement, but was subject to the leading questions of a skillful prosecutor in a question-and-answer confession. He was subjected to questioning not by a few men, but by many. They included Assistant District Attorney Goldsmith, one Highland of the District Attorney's Office, Deputy Inspector Hulks, Lieutenant Gannon, Detective Chacon, Detective Mata, Detective Lehrer, Detective Marshall, Detective Farrell, Detective Lyra, Detective Mercy, Detective Murtha, Sergeant Clark, Patrolman Bruno, and Stenographer Baldwin. All played some part in the effect of such massive official interrogation must have been felt. Petitioner was questioned for virtually 8 straight hours before he confessed, with his only respite being a transfer to an arena presumably considered more appropriate by the police for the task at hand. Nor was the questioning conducted during normal business hours, but began in the early evening, continued into the night, and did not bear fruition until the not too early morning. The drama was not played out, with the final admissions being obtained until almost sunrise. In such circumstances, slowly mounting fatigue does and is calculated to play its part. The questioners persisted in the face of his repeated refusals to answer on the advice of his attorney, and they ignored his reasonable request to contact the local attorney whom he had already retained and who had personally delivered him to the custody of these officers in obedience to the bench warrant. The use of Bruno, characterized in this court by counsel for the state as a childhood friend of petitioners, is another factor which deserves mention in the totality of the situation. Bruno's was the one face visible to petitioner in which he could put some trust. There was a bond of friendship between them going back a decade into adolescence. It was with this material that the officers felt that they could overcome petitioner's will. They instructed Bruno falsely to state that petitioner's telephone call had gotten him into trouble and that his job was in jeopardy and that the loss of his job would be disastrous to his 3 children, his wife, and his unborn child. And Bruno played this part of a worried father, harried by his superiors, in not 1 but 4 different acts, the final one lasting an hour. Petitioner was apparently unaware of John Gay's famous couplet, "An open foe may prove a curse, but a pretend friend is worse," and he yielded to his false friends' entreaties. We conclude that petitioner's will was overborne by official pressure, fatigue, and sympathy falsely aroused after considering all of the facts in their post-indictment setting.